Welcome to RPRA's Understanding Ontario's new EEE regulation. At this time, all lines are in a listen-only mode. To ask a question at any time during the presentation or for technical assistance, please type your question in the text box provided on the screen and press enter. As a reminder, this webinar is being recorded. I will now turn the webinar over to Jess Turquette, Communications Advisor at RPRA. Please go ahead.
Good morning, everyone, and thank you, Robin, and thank you all for joining us today. We're hosting this webinar to provide an overview of the new regulation for electrical and electronic equipment with a focus on outlining the requirements for producers of EE. So as Robin mentioned, feel free to ask questions at any time throughout the webinar. You can do so on the right-hand side of your screen where you'll see the little text box. There are two tabs at the top, one for Q&A and one for tech support. So if you are experiencing any sound or lagging or anything like that, any technical issues, please type them into the tech support tab and you will receive dedicated support to that. We will be pausing throughout the presentation to address your questions. I will note that we're expecting over 250 attendees today, so and we only have 2 hours, so we will try our best to get to all of the questions, but if we are unable to answer yours, we will be following up with you after the webinar, so stay tuned for that. We will, as always, be posting this presentation slides as well as a recording of the webinar to our website later this week. So with that, I will now hand it over to Pat Moran, RPRA's registrar, who will lead the presentation.
Thank you, Jess, and good morning, everybody. We have a very large turnout for today's webinar, and I'm looking forward to walking you through the regulation and hoping to answer as many of your questions as possible that you may have today. And as Jess indicated, we will follow up if we don't get to everybody's questions, and we may have some additional sessions like this to focus on key sets of issues if that's what emerges out of here. Just starting off, all of us have been working from home in response to the pandemic, but all of our services remain fully available. Our compliance team has continued to operate the existing compliance program, and of course they've been getting ready to support those folks who have to register under this new regulation. The slide here shows how to contact our registry team, so you can reach us by email and you can reach us by phone as well. And we're happy to have a conversation with anybody who has questions around this regulation as the process continues. We also have on our website a significant amount of information around the electronics reg, and we'd encourage you to visit that as well. So today, we've got a number of topics to get through, and we're going to start off with the general definition of what E is, and then we're going to talk about who is a producer for ITT and audiovisual electronics equipment, and then we'll talk a little bit about service providers and municipalities and their role under this reg. Then we'll spend a little time going through the collection and management requirements that have to be met, and then the registration process and some of the relationships between key players. So let's get going. So starting point, what is electrical and electronic equipment? Back in May of 2019, the ministry posted a draft regulation. It finally got released a couple of weeks ago. The windup of the program, of course, is happening at the end of this year, so there's not a lot of time between the publication of this regulation and the windup of the existing program that's operated by the Ontario Electronic Stewardship. Starting January 1st, under this regulation, the producers that are captured by the regulation will now become individually accountable and financially responsible for the collection and the recovery of resources from the products that they supply to end users here in Ontario. This is a new system that's fundamentally quite different from the system that producers are currently familiar with under the Ontario Electronic Stewardship. And we're going to talk about some of those fundamental differences and what they mean. Under the Resource Recovery and Circular Economy Act, the authority is the regulator who's responsible for implementing these regulations and for enforcing the requirements under those regulations, as well as and not just this one, but the existing tires regulation and batteries regulation and the subsequent regulations that may be released by the ministry. Let me just spend a moment briefly on the structure of the regulation. I think it's really important to emphasize the fact that the regulation operates against a legislative background. So there are provisions in the legislation that are important to take into account. And then there's the provisions that are in the regulation itself, which provide the details about how this program works. And as you read through the regulation, you will see that there is a reference to registry procedures that are published by the authority. In effect, those registry procedures have been incorporated by reference because they're named in the regulation, and so essentially form part of the regulatory context. It's very important that for those who want to understand all of the obligations that are created by this regulation, that you look at not just the regulation, but you also look at the registry procedures that are incorporated by reference in the regulation. That's the complete regulatory package, and everything collectively in those three documents essentially forms the regulatory program for electronics and electrical equipment. The registry procedures are on our website. When you go to our website, you will see a page for E, and then when you click through, you have access to the relevant registry procedures, as well as compliance bulletins that we issue from time to time. One of the things that we've done for previous regulations is to, in order to support people's understanding of what the requirements are, we have issued compliance bulletins on specific issues, and we intend to do the same thing to assist registrants under this program as well. One of the compliance bulletins that's currently been published for the electronics program is one that relates to how to apply for extensions. We recognize that for a combination of reasons, the impact of the pandemic, the very tight time frame between the release of the electronics reg and the wind up of the existing OES program, that it may be that somebody is facing circumstances that will make it very difficult to meet filing requirements under the regulation. And so there is a compliance bulletin that addresses that issue, and for those who find themselves suffering from those constraints, we encourage you to reach out to our compliance team and have a conversation with respect to solving that problem. So, what is electrical and electronic equipment? So what the regulation does is it starts at a high level. Essentially, it's equipment that's designed for use with an electrical current, has a voltage of less than 1,000 volts if it's AC current, and less than 1,500 volts if it's DC, and on an individual use basis weighs less than 250 kilograms, and isn't intended to be used permanently as part of a building or a structure. So not intended to capture elevators and escalators and things like that, which would be more than 250 kilograms in any event. So this basically, comes down to anything that has a plug or a battery, and so very high level definition. And then it applies to all of the electrical equipment that's supplied to any end user in Ontario. So it's not confined to residential end users. If it's supplied to anybody in Ontario, it's captured under this regulation. So to a resident, to a residential consumer, to a business, to an institution, commercial end users, industrial end users, anything that falls within the definition and is subject to the registration and reporting requirements, it's captured from all of those users. It also includes anything that's supplied with the equipment, and in particular, batteries. A lot of electronics comes with a battery. Clearly, cell phones are sold, containing a battery. Laptops are sold containing a battery, and so for the purpose of this regulation, the battery is part of the electronic equipment that is captured under this regulation. And by the same token, people who supply replacement batteries for that equipment, so a cell phone producer who sells cell phones with batteries may also be selling replacement batteries for that equipment. For the replacement batteries, they would be a producer under the batteries regulation and would report the battery's weight of those replacement batteries under the batteries regulation, and the weight of the embedded batteries would be included under this regulation. So for practical purposes, it means that you may be a producer under two regulations and have reporting requirements and performance requirements under both of those regulations. To some extent, that as part of the fee setting process, that overlap has been recognized as folks will have seen from the recent decision on fees on registry fees from the authority, that there's the fee that's charged under batteries and electronics is the same fee based on the weight of batteries supplied under the batteries regulation and the weight of electronics supplied under the electronics regulation. So that's the high level kind of structure of the regulation. What the regulation does next is it creates two specific categories of obligated electronics. So the first category is the information technology, telecommunications, and audiovisual category, and the second category is lighting. So these are just two categories of E, and they each come with their specific requirements. We're not going to talk anything about lighting in this presentation for the simple reason that lighting producers and service providers don't have to register under this regulation until November 30th of 2022. And the first performance period for lighting doesn't begin until January 1, 2023. Closer to that time, of course, we will hold information sessions like this one for lighting producers. But in the meantime, for the purposes of today's presentation, we're going to focus on the ITT and AV category. So moving from the sort of general high-level definition of E, we now have a specific definition for ITT and AV within that higher level definition. And basically, it's down to what the primary purpose of that equipment is. And so anything whose primary purpose is for the collecting, storing, processing, presenting, or communicating information, which includes sounds and images, recording or producing sounds and images, and is under 250 kilograms on a per unit basis, that anything that falls within that definition is ITT and AV for the purposes of this regulation. Now, in previous programs and in other jurisdictions, people may be used to seeing very specific lists of equipment. That is not the approach that's been taken under this regulation. There is a definition, and to support the definition, there is a schedule that provides some examples that would fall into that category, and it's clear on how it's presented in the regulation that these are examples and not a definitive list. Our approach to determining what falls within this definition is pretty straightforward. We just simply take the definition, that primary purpose definition, and when we're looking at a particular type of electronics, as a team, we've been walking through and just saying, so what does this piece of electronics actually do in the context of the primary purpose of collecting, storing, processing, et cetera, et cetera. Our experience with that has been that 99% of the time, the answer is pretty obvious. It's either in or it's out. And of course, 1% of the time, there's a gray area piece of equipment that we end up as a team having a really interesting debate about whether it's in or it's out. My favorite example is a product that's on the market right now. It's a light bulb that comes with a Wi-Fi enabled speaker, which you could put into your porch, I guess, and use as a light as well as play music over. So we got to this one and said, so what is it? Is it ITT and AV or is it lighting? And we had our good debate about it, and we landed on the page that based on the primary purpose, definition for ITT and AV versus primary purpose for lighting, that it was in the lighting category and not in the ITT category. So that's the kind of process we're going through. And I know that folks have been phoning in to ask specific questions around whether certain equipment is in or out. And we would simply encourage you to, walk yourself through the same process that we do, and just, objectively ask yourself, what does this thing do? Does it collect, store, process? And if the answer is yes, and it's an easy answer, then just, run with that answer. If you're not sure, then absolutely feel free to reach out to our team, and we'll help you with determining whether it should be reported or not. So important to understand that the schedules don't contain complete lists. We are working our way through a process to provide a compliance bulletin that will provide a bit more information about the products, the types of products that we think are captured, and we will be posting that as soon as we're finished our process in the next week or so, and that'll be posted on our website. So this slide basically shows what Schedule 1 in the regulation uses as examples of things that are captured by the definition of ITT and AV. So using the examples in this schedule and using the definition, as I say, just walk yourself through the process with respect to your own products. If you're a producer and wondering if your product is in or out. And then if you conclude that it's in, great. If you're worried about whether it's in or out, give us a call, as I say, and we'll try to help you on that. There are some specific exclusions, and again, just to help with a little bit of certainty. So things like cash registers and checkout machines and ATMs, street lights, traffic lights. Clothing and furniture that comes with electronics built into it, and of course, motor vehicles, all of which come with electronics these days, etc. These things are all excluded, and one of the exclusions, which I'll just expand on a little bit right now, is electronics that falls under the definition of device, as that's defined in Section 2 of the Federal Food and Drugs Act. So basically, device is defined to be anything that's used for the purpose of diagnosing or treating or mitigating or preventing disease or disorders. So for example, the electronic thermometers, they might otherwise be in because of the definition, but they're excluded because they're a medical device based on this definition. So all of those devices that are used in a medical setting that are electronic, generally based on the definition of device in that act, are excluded. So you might, based on the type of products you produce, you might want to have regard to that definition. And again, if you're concerned about whether it's excluded based on the definition of device, again, feel free to give us a call, and we'll help you out with that as well. I think this is a good point to stop for some questions. So in terms of the overall overview this regulation.
Great. So our first question today, since motor vehicles are exempt, are replacement of factory-installed communication devices developed for embedded use in motor vehicles exempt, as has been the standard for EE programs across Canada?
Yeah, so I think the way the regulation is written, the electronics that come with the vehicle when you purchase the vehicle are exempt. The aftermarket electronics that are used for installing into a vehicle are not exempt. They're captured to the extent that they fall within the definition of ITT and AB.
Great. Next question. I think this is looking just for some clarification around the weight. So if we are a company that offers equipment to our clients, however, it does not weigh more than 250 kilograms, does this apply to us?
Yeah, so if the equipment is on a unit basis less than 250 kilograms and it fits within the definition of ITT and AB, absolutely is captured by the definition.
Great. Next question. We are a computer store. Does that make us a producer, or is this program going to be focusing on the actual manufacturers?
So there are some slides coming up that are going to talk about who's a producer. So I'll wait till those slides come up and we'll address that question at that point.
Okay. Are refurbished devices and refilled printer cartridges in scope here?
So refurbishment is an example of resource recovery under this regulation. So if I'm a producer who has supplied electronics that fit within the definition of ITT and AB into the Ontario marketplace, that supply weight is used to calculate a minimum resource recovery management requirement. So I'm based on what I've supplied, I'm required to recover resources at a percentage of that weight. And resource recovery can come in a couple of forms. The dominant form at the moment is processing, where electronics are collected and then sent to a processor who processes those to extract materials from those used electronics. The other way to meet your resource recovery requirement is through refurbishment, and so the weight of that refurbished equipment counts towards the performance requirement, and if it's refurbished equipment that comes from a refurbisher who's located in Ontario, it counts double. So that's where refurbished equipment fits in. This is really intended to apply to the requirement for producers to report what they're supplying. It's intended to apply to new equipment, recognizing that refurbished equipment is meeting the objective of this act, which is to ensure the highest level of using the use of resources, particularly through things like life extension as a result of refurbishment, etc.
Great, thanks, Pat. This is a bit of a comment/question. With the vague nature of what and what is not obligated, do you foresee there being issues with harmonization to other provincial programs, specifically when it comes to systems that companies use to obligate their own products?
Mm-hmm. I mean, certainly across both Canadian and American jurisdictions, there is a wide diversity of approaches to producer responsibility. We have several different types of models of extended producer responsibility, and we have the individual producer responsibility model here in Ontario, and some examples of that in some other jurisdictions in the United States and in Europe. There isn't a great deal of harmonization to begin with, because each program operates based on the regulatory requirements of those individual jurisdictions. I think the key here is just to make sure that you understand how this regulation works for the purposes of Ontario, Specifically, what we have in this regulation is an outcomes-based regulation that says, once a year you're going to report some historical supply data, and that's going to be used in a formula to establish a performance obligation, and which you will also report on the results of once a year, and then you're going to go to a competitive marketplace to contract with service providers to help you as a producer to meet your individual requirements. So that, I'm not sure I can say much more about harmonization than that.
Great. Will the authority's website be updated to include list of items determined to be included and/or excluded?
Yes, as I indicated a few minutes ago, our process, and we encourage everybody to use that process because it works very well, is just, take a look at your equipment, take a look at the definition of ITT and AV and the exclusions from that, and then just see if it logically and objectively falls naturally within that definition. Our experience in going through a wide range of materials is that the answer emerges very naturally and very easily, 99% of the time. And then there's a few items that raise some interesting questions and some debate. So, and as I said, for those items, definitely feel free to reach out and have a conversation with us on that. And we are going to be posting very shortly a compliance bulletin that will expand on the examples that are in the schedule, and we'll continue to add to that as people bring equipment to our attention and we have the opportunity to consider it.
Thanks, Pat. So this question is more about the regulation of policy itself. So why does the regulation not include household appliances, toys, leisure equipment, tools, navigational, medical, or control instruments?
So the ministry is responsible for developing the regulation, and so they posted a draft regulation for public consultation back in May of 2019, and then they went through their process of finalizing the reg, presumably including feedback that they received from various stakeholders. So ultimately, the policy basis for excluding those items is a question that you should raise with the ministry.
And our last question before we move on to the next section, just to clarify, aftermarket toner cartridge for printers, are aftermarket toner cartridges for printers exempt from the new regulation?
They are not. The replacement electronics that are included in the definition of the electronics that are to be reported on.
Okay, thanks, Pat. We'll move to the next section.
Okay. So I'm going to talk now, just following up on an earlier question from somebody who's wondering if they're a producer. So who is a producer? The regulation essentially has a hierarchy that applies to determine if you're in your circumstances a producer. So at the top of the hierarchy is the brand holder. So the person who's the brand holder who is resident in Canada, even if not resident in Ontario, is going to be the producer for the products that brand holder supplies into Ontario. If there is no brand holder resident in Canada, and that's certainly the case for lots of electronics, then the question of who's the producer comes down to who's the person who imported that equipment into Ontario. And so if you're a resident importer in Ontario for that equipment, then you will be the producer for that equipment. So in the case of somebody who's operating a computer store who brings equipment in for which there isn't a registered producer elsewhere, that equipment that you bring in to Ontario, you will become a producer for the purposes of that equipment. So it comes down to what it is that you do. If there's already a resident brand holder in Ontario or in Canada for that equipment, then they're the ones that are responsible for reporting that supply, because they'll be supplying it to your store and other people in Ontario, and they're going to report their total supply. Where there isn't that resident brand holder and you're the person that's actually bringing it into Ontario, then you become the producer for that equipment. If there isn't a resident importer, then it's the person who's resident in Ontario who's actually marketing that equipment to members of the public. So again, from that sort of computer store context, there may be an importer who is located in Manitoba or Nova Scotia, and you're getting that equipment from that importer, but that importer is not resident in Ontario. But you're marketing it in Ontario through your store, then you're going to be the producer for that particular equipment, and only that equipment, and not the rest of the equipment that you may be marketing in your store. And then ultimately, if there's no resident person in Ontario marketing that electronics, then it's the non-resident marketer, and this generally tends to capture the online people who don't have residence in Ontario. There are significant online vendors who do have residency in Ontario, and so they would be captured there. But if they don't have residency in Ontario, then they're responsible as the producers that are marketing that equipment into Ontario. The definition of what it means to be resident in Ontario or Canada is basically comes down to having a permanent establishment as defined in the income tax regulation, and so again, you should have regard for that. I mean, generally, as a general proposition, there are some legal complexities to this reg, and to the extent that we can provide some compliance guidance, of course we will. But ultimately, people should make sure that they understand what they're legally obligated to do, and to get legal advice as they may require. There are exemptions under the regulation. Before there's any reductions to your supply data, so this is really just a reference to the fact that when you report your supply data in, there are some ways in which you're allowed to reduce that reported supply data for some specific policy reasons, and I will be talking a little bit about that in a minute. But before any reductions, so you determine what your supply is into Ontario, and based on knowing what the weight of what you have supplied into Ontario, if the management requirement that's calculated based on that supply data is less than 3.5 tons, then you will be exempt from the requirement to register and report to us, and therefore obviously exempt from establishing a collection or management system and all the promotion requirements. It's important to know that that percentage, that management requirement percentage, is changing over time. So you might be exempt in year 1 and year 2, but you might not be exempt in year 3 and year 4 or year 5 because of the escalating management requirements over those years. And it's also important to note that even if you're not required to register, you are required to retain records about what you actually have supplied into Ontario, and of course that means that our inspectors have the ability to look at those records and confirm compliance with the requirement and whether you meet the exemption. So this table is basically to help you understand what the 3.5 ton exemption limit means in terms of what you've supplied into Ontario. So the management requirement, because it's calculated based on what you've reported as your supply into Ontario, converts into the 3.5 tons is the equivalent of 6,300 kilograms or 6.36 tons of supply. So, and that's because the supply is multiplied by that 55% factor that you see to get to the 3.5 tons or less. So if you know that you're supplying, for example, 10,000 kilograms as your average annual supply into Ontario, then clearly you're above the 3.5 ton exemption based on the performance management that would be calculated from that. So there are two ways basically to determine if you are exempt. You can do the calculation yourself and see if, as a result of that calculation, based on the relevant calculation for that year, that you're under the 3.5 ton cutoff, or you can just use these supply numbers, the 6360 and then the 5830 and the 5380, et cetera, down to 5,000. This table demonstrates the point I was making a minute ago, that even if you were exempt in 2021 based on the calculation for 2021 and the calculation for 2022, you might not be exempt in 2023 because the supply threshold has dropped from 6360 down to 5830. And in 2024, it drops again down to 5380, and finally in 2025 down to 5,000. And then after that, if you're still exempt, then you will continue to be exempt. So it's important to pay attention to what you're supplying each year and to determine if, based on the calculation and the formula that applies to that year, are you still exempt. So we talked about what a producer is, and there is an obligation, obviously, if you aren't an exempt producer, to register and report. But then there's this concept called a volunteer organization. And what does that mean? Basically, a volunteer organization is a person who is a brand holder, but in this particular case is not resident in Canada. So on a voluntary basis, this brand holder has decided to enter into an agreement with the people who otherwise would be the producers who have to register for that brand holder's supply into Ontario because of their residency. On a voluntary basis, can enter into an agreement, and having entered into that agreement, has to register with the authority and then meet all of the reporting and requirements and all the performance requirements. This means that now we have somebody who's not resident in Ontario taking all the obligation for all of those producers who otherwise would have registered as the producers for that person's product. And essentially what we have is a set of unregistered producers who remain obligated for meeting all the requirements, but that's not a problem as long as the volunteer organization is meeting all of the requirements. But if the volunteer organization fails to meet the reporting and registration requirements and performance requirements, then those individual producers are back on the hook fully and having to deal with that compliance problem at that point. We haven't had any take-up on this under the batteries regulation. Not sure whether there's going to be a lot of take-up under this regulation either, but we would strongly encourage that anybody who is a producer and is looking at working out an agreement with a volunteer organization for the purpose of this section to talk to us to make sure that all the requirements are understood and being met so that this can work the way it's supposed to work. Then this takes us to the section 6 that's in the regulation. So under section 6, a producer has to register. So all producers who are within the definition of producer and who aren't exempt from based on how much they're supplying in Ontario and are supplying ITT and AV based on the definition, all of those producers have to register. There is no alternatives for that. And then having registered, it is open for individual producers to enter into written agreements with service providers. And obviously those service providers will typically be service providers who are competing for that producer's business to meet the producer's requirements under the regulation. The vast majority of the service providers we expect based on our experience with some of the other regulations, will be organizations called producer responsibility organizations. So producers have the opportunity to sign up with a producer responsibility organization, and we'll talk about that in a few minutes a bit more. And or they can sign up directly with processors who can meet their processing requirements, their resource recovery requirements, and so on. And there's a number of different options, and it's really down to what's the best path forward for a producer. So what it means then is that those people can carry out reporting. So we have built a registry that is based on a couple of principles. The first principle, of course, is that a producer's market data is commercially sensitive information. So when a producer puts that information into our system, we are firmly on the page that there is an expectation on the part of individual producers that their commercially sensitive information is going to be protected. So we have built the registry to meet that legislative requirement on our part to maintain confidentiality of commercially sensitive information, so that that information can only be entered through a producer's account, and that's it. And each individual producer, in setting up their account, of course, has the ability to authorize individual users in their account, and then that's really down to each individual producer assessing their business risk in terms of how they want to manage their commercially sensitive information when they hand it over into the registry, and who it is they're going to let see it outside of the registry. So what we found in the tires registry, that essentially every producer is entering their own supply data. They come in once a year and give the next round of supply data. They get their performance requirement, and then they go off to their pros and say, this is my minimum performance requirement, and then they enter into contracts to meet those requirements. So it works very well, and it's very, very simple, and it takes advantage of the functionality that we've built for tires and we've built for batteries and for electronics all the way through. There are some practical limitations. And it's very important, I think, that producers understand these practical limitations. We know that we're aware of some conversations out there that are premised on the idea that somehow under the new regulation, things can operate exactly the same way as they did under the old regulation. And that's simply not true and not possible. The old regulation, the old program under the Ontario Electronic Stewardship was fundamentally different in many very important ways, and it's simply not possible to continue to perform under the new regulation the way people performed under the OES program. They're basically night and day programs. And one of the clear examples of things that have happened that occurred under the OES program was the idea that there was these remitter arrangements where a remitter who was retailing products from a wide range of producers directly reported the units that they sold to OES, and then OES arranged for a resource recovery program, and then based on the cost of that program, billed it back based on how many units were sold in. There was no individual producer responsibility in this context at all. In fact, OES didn't have a line of sight to most of the stewards in the program because of this. Under the new regulation, the structure is fundamentally different. Each individual producer now has to come in and now has to register and is legally accountable for their own supply data and the accuracy of their supply data. And the one thing that we are not able to do under the new in the registry is for piecemeal reporting of supply data. The obligation on a producer is to provide their annual supply data and as a number, and there's no functionality available. And in fact, it would be we could spend millions and millions of dollars trying to figure out a way to do that, but we just don't see how that's possible to do that in the context of individual producer responsibility. So the easiest thing and the most practical approach in that context is if a remitter was reporting some of your supply data to OES, instead of reporting it to us, they can report it back to you, and then you just, as a producer, have to come in once a year and give us the total number. So really cheap, really simple, really administratively straightforward process. This regulation is really an opportunity for producers to realize some significant reductions in administrative burden. And that administrative burden, you know, under the IFO model, includes things like monthly supply reporting and things like that, which you don't have to do anymore under this regulation. This regulation simply requires you once a year to report your supply data to the authority, get your annual performance requirement, and then you could take that annual performance requirement to the marketplace and people will say, this is what I'm going to charge you to meet that requirement. Anybody who chooses or wants to or is told, no, we can do it the same way, you can still report all your data monthly and so on. I think you should be asking yourself, why would you keep that administrative burden going when there's no purpose to it? So we've set up a system that works really simply and really well for supply reporting. On the performance reporting side, knowing that service providers are generating that performance on behalf of producers, the registry has built, because we don't have the same commercial sensitivity issue for performance data, the registry has functionality in it that allows the service provider, the pro or whomever, to report the performance that they created for that producer into the registry, and so that it's accounted for in the producer's account. They don't get to see what's in the producer's account. They do get to see what they reported in, and the producer always gets to see what's being reported by their pro in terms of performance. So again, this allows for that competitive marketplace to operate, so that producers have the ability to contract with any pro that they want, to change their pros at any time that they want to have more than one pro based on the kind of material they produce, and all of which knowing that when those pros are reporting performance, and they can only do that if you consent to it, we'll never see your commercially sensitive information on your supply side. And this is really critical in ensuring, we have heard from producer after producer after producer that their number one concern is that their commercially sensitive data is safe. And so that's how we built the registry, and that's basically how it works. And this is how we will implement the producer agreement section in this regulation. You have to know that producers, regardless of whatever agreements they have with their service providers, always remain obligated for their obligations under the regulation. And regardless of how the service providers perform, the compliance obligation always remains with the obligated producer. I'm going to spend a couple of minutes talking about a bit more about service providers and municipalities. So the list of service providers obviously includes producer responsibility organizations, but it also includes haulers, processors, and refurbishers. So these are all folks that have to register separately with the authority. A hauler is basically anybody who arranges for the transport of ITT and AV, and I'll just spend a minute on that, because we know that in some instances, people retain the services of a FedEx or a Purolator or a Canada Post to pick stuff up and move it, and which may include picking up and moving some waste electronics and delivering them somewhere for processing. We are not expecting FedEx and Purolator and Canada Post to register as haulers with us. What we're expecting is the person that arranges for that transportation is the person who will end up registering with us. Because what we need is the person who actually knows what's being transported. And a Purolator or a FedEx or a Canada Post operator may not necessarily know what's in the package that's being moved, but the person who arranged for it definitely does. So if you're a broker that's arranging for transportation, of used electronics to electronics processor, et cetera, you're the one that's arranging for the transportation, therefore you're the hauler for the purposes of this reg. So that's a bit of a nuance for that. The others are pretty straightforward. They're defined pretty clearly. So a ITT and AV processor has to register if they're in the business of processing ITT and AV for the purposes of resource recovery. And there is a requirement for those processors to meet a prescribed recycling efficiency rate, and which in due course will have to be verified in accordance with the registry procedure that's referenced in the regulation, and has to comply with the requirements in that registry procedure as part of complying with this regulation. That registry procedure, as I said, is available on our website, and similarly, a refurbisher who refurbishes for the purposes of reuse and life extension also has to adhere to the standards set out in the registry procedure as it applies to refurbisher. So the standard for processors is the international R2 standard. That's the standard that has to be met by processors. The refurbishers, recognizing that depending on the size of their operation, there are some specific requirements if they're not R2 registered. But of course, if they are R2 certified, that's great. But as long as they meet the minimum requirements in the registry procedure to meet the standards that are set there, then that's all they have to do. We don't have, unlike tires, for example, where there are individual tire collectors who register. We don't have that concept in this regulation, but collection sites are defined for the purposes of the collection system requirements, and we're going to talk a little bit more about that in a couple of minutes. So a producer responsibility organization is basically anybody that's retained by the producer that arranges or actually establishes the collection systems and management systems for ITT and AV, and is retained for preparing and submitting that performance reporting that I spoke about a few minutes ago. For municipalities, and I know there are some representatives of municipalities participating today. A municipality can obviously continue to operate collection sites for ITT and AV as they might be doing currently. There's no requirement, as I said, for collection sites to register with the authority. But it's important for a municipality to understand that if you're going to continue to operate that collection site, if you want that collection site actually to be serviced, for what you collect to be picked up by somebody, you will have to have a contract with somebody to do that. So with a producer or with a pro on behalf of a producer or with a processor who's going to market collection and processing services to pros. So just make sure that you understand that if you're going to continue to operate these collection sites, that and you want them to be serviced by a producer or a pro on behalf of a producer, make sure you've got the appropriate commercial terms in place to cover the servicing and cost of that site. I'll be getting a bit more into the details of the collection site requirements a few slides from now. And one last point for a municipality, you may also fall within the definition of a hauler, in which case you would have to register with, and this would be the case in which the municipality actually transports the ITT or arranges it for its transportation to a processor or to a refurbisher. And of course, it depends on ultimately who actually arranges for it. So there's two ways it could happen. The municipality might be arranging for it, which would make them a hauler, or the municipality has a contract with a processor or a refurbisher, and that person is actually arranging for the pickup of those. So in which case, the other person would be the hauler as well. Anyway, anybody who has any specific questions around the details of how this operates, they should contact our compliance team, and we'll do our best to help you out on that. We will be having a more detailed presentation for municipalities in partnership with AMO, and I think that is currently being scheduled. I'm going to stop there for questions. We have talked about a lot, and it's a very dense regulation, and I know people have lots of questions, so happy to take some questions.
Yes, we have a number here. I do want to mention, as I did at the beginning, with the high number of participants, we are getting a high volume of questions. So again, if we cannot respond to your question during today's webinar, live on the webinar, we will follow up with you directly after the webinar. So again, we are getting quite a few questions, so it's unlikely we'll be able to get to them all, but don't fear, we will respond to you via email or phone call after the webinar. The first question here, Pat, is if a brand owner is resident in Canada, only paying tax in Canada for services and not for selling obligated electronics, is the company exempt?
So if a brand holder is resident in Canada and is supplying electronics that fall within the definition of ITD and AV into Ontario, and they're supplying more than 3.5 tons of a performance management requirement, they're not exempt. So if you have a permanent establishment as defined under the Federal Income Tax Act regulations in Canada, and you are the brand holder for the material that you are supplying into Ontario, you're the producer for that material. In terms of how this works out in your specific instance and what the fact situation is that you're operating under, I think we can talk directly with you on that, but that's the general proposition. And of course, to the extent that there's a legal component to this, you should obviously seek legal advice if you're uncertain about what your legal position should be.
Next question. We have third-party marketplace sellers that may sell electronics on our website. Would the marketplace seller be responsible for determining whether they are a producer?
That's an excellent question. So again, it comes down to that definition of who a producer is and what is the activity that person is engaged in. So if you're marketing material into Ontario, to Ontario end users, you are going to be the producer based on the residency requirements that are set out there, regardless of whether you're an online entity or a bricks and mortar or even a combination of that.
Great. Does Section 6 potentially remove the individual producer responsibility obligation on the producer?
Absolutely not. It's in fact is very clearly written to state the opposite, that it never removes it.
Okay. How do you determine supplied into Ontario? I ship product to a distribution center in Ontario, and my client redistributes to retail locations outside of Ontario.
Mm-hmm. Yeah, so this is a standard problem for all producers who operate in that context under all of the programs, including the ones that existed before these regulations came along. I'll use the tire program as an example. So under the Ontario Tire Stewardship Program, stewards reported their market supply into that they supplied it into Ontario, and of course there was always the reality that particularly for tire producers who were tire producers because they were selling new vehicles into Ontario. So clearly a car manufacturer supplying to a distribution center in Ontario, which may then end up moving those cars to Manitoba or into the United States and all. The question is, how do you get to that net number? And Ontario Tire Stewardship worked out a process to get to that net number. People reported their supply, and then they had an opportunity to adjust that supply. So exactly the same thing happens under the new regulation, but it's actually a lot simpler than the old process, because you don't have to report current market supply anymore to anyone if you don't want to. All you have to report to us is your historical supply data. And so to the extent that historical supply data is historical, you have the opportunity to adjust for the fact that some of it may have been distributed back out of Ontario. So it's a relationship between you and that distributor, and the reporting of where the product went in terms of being able to identify what stayed in Ontario and was given to an end user in Ontario. This is not a new problem, and it's pretty much sort of a standard operating requirement for all of these programs across jurisdictions. You really just come down to an adjusted supply amount based on the net supply that stayed in Ontario.
Thanks, Pat. Can a producer assign a portion of their responsibilities to another party? Could retailers fulfill EHF's collection and remitting obligations without taking on the collection requirement responsibilities of the individual producers?
So the opportunity for a producer who has to meet the requirements under this regulation is they have access to a competitive marketplace which has service providers that they can enter into agreements with to do things for them. So this question really gets at, what kind of commercial arrangement can I enter into with a producer to meet that producer's requirements? And so a producer, for example, could say, I've got 3 different kinds of things that I supply into the marketplace, and there's a pro out there who specializes in processing this particular kind of stuff that I supply in the marketplace. So I'm going to have a contract with them. And then there's another service provider out there that specializes in something else that will meet my requirements, and I can have a contract with them, and someone else who specializes in other things, and I can have a contract. So you can contract with as many people and mix and match so that your total obligation is covered by a range of contracts, as long as at the end of the day, you're reporting your supply data to determine what your performance requirement is, and you're monitoring your performance, the performance of those contracts to make sure that your performance obligations are being met by your service providers, and understanding that we have a registry that allows each one of those service providers to report performance on your behalf, and you'll be able to see through the registry what they're reporting. But more importantly, you'll have your own contract management system in place to manage your contracts. The reporting requirements are after the fact. So performance takes place over a year, and then the reporting requirement is in the following year, same way as you do income taxes. So, you earn money over the course of a year, and then in the following year, by April 30th, you report how much you earned and what deductions you're entitled to, et cetera, et cetera. So.
Thanks, Pat. A couple more questions. If a producer chooses to work directly with a processor to meet their obligation and would like the processor to report on their behalf, does the processor have to be registered as a pro?
If the contract is between a producer and a processor, and what the processor is doing is providing processing services, and that's it, the answer is that they do not have to register as a pro. How often that's the practical situation remains to be seen. In the tire world, typically processors also operate at collection systems, and so because they were offering a combination of services beyond processing, they registered as pros because of the definition of pro. So, but the narrow answer is they don't have to register pro if they're just contracting for processing. And in terms of being able to access the reporting requirements, well, those reporting requirements for performance are engineered for pros. The setup was specifically based on a license, a Salesforce license, which is what our platform is built in, that pros operate under. And but it would be a very simple, straightforward proposition for the processor to say, here's the performance I created for you, and then as the part of that annual report, the producer just reports that performance. And as I say, it would be a straightforward proposition and a very simple thing to do.
Okay, great. In a situation where you routinely collect your own gear, for example, end of lease, and refurbish for resale, would you have to register as a producer and refurbisher?
Yeah, so as a producer, you're reporting your supply. As a producer, I guess you're relying on yourself to meet your performance obligation through refurbishment, and the person that's doing the refurbishment happens to be you. So yes, you would register as a refurbisher, and as a refurbisher, you would report on what you refurbished, and as a producer, you would report the same number. So again, it would be a very straightforward proposition, but technically you would have to register as a refurbisher because performance has to be delivered by registered refurbishers and registered processors. The registration process for refurbishers is very, very simple and very straightforward, and ultimately the reporting requirement will be very straightforward as well.
Okay, great. So last question before we move to the next section. Could you please go back and explain how to use the two different exemption thresholds, the 3.5 tons of management requirement versus the kilograms supplied? So I can just push back to that slide.
Yeah.
There you go.
I'm doing it. There we go. Hang on. There it is. Okay. So we have provided this information because without this information, if you want to know if you qualify for the 3.5 ton exemption, you have to go through the reg and understand how to calculate your performance management, and then you have to figure out what your supply data is. And we thought it would be easier if we just say, based on the formula that gets you to the number that you would compare to the 3.5, what is the supply data that would give you, the 3.5? And so based on that calculation, we just sort of reverse engineered it. So for the years of 2021 and 2022, if your average supply data, so in 2021, your 2018 supply data is less than 6360 kilograms, or in 2020, your average 2018 and 2019 supply data is less than 6360 kilograms, then you're exempt. You can do the calculation yourself, and then you'll get a number that's less than 3.5, and you're still exempt. So we just thought the easiest thing to do is, here's the supply data that gives rise to the exemption of 3.5 tons. This is going to be posted on our. This will be posted on our website as well, so you'll have the ability to have reference to this. And and we'll have some compliance bulletins that provide this information as well. It's a bit awkward for somebody to have to go through the whole calculation process to see if they're under the 3.5 tons. So we're just trying to make it a little easier to say, look at your supply data for the 2021 period. If it's less than, if your 2018 supply data is less than 6360, you're exempt. In the 2022 period, if your average of 2018 and 2019 supply data is less than 6360, you're exempt. In 2023, if your average of 2018, 2019, and 2020 supply is less than 5830, you're exempt. And the reason that number drops is because the performance management requirement changes from a 55% recovery rate to a 60% recovery rate. And so the supply data number that gets you exempt is dropping because the performance management is tightening up.
And this is just just another question related to that regarding the supply. Is there any table containing unit weights versus the kilograms supplied for the exemption calculation?
Yes, we have developed a weight conversion weight conversion factors for different categories of E. Again, that's available on our website, so you can have regard to that. I'll be talking in a few minutes about how you determine what your actual supply data is, and there's a number of ways of going about it. So that information is coming up.
Okay, Pat, that's all the questions for now.
Okay. Good. So collection and management requirements. As a sort of from a conceptual point of view, it's really, really important to understand that the collection system is what drives all of this. And the collection system is a fundamentally important part of producer responsibility under the regulation. The requirements are set up so that regardless of where a consumer or an end user, I should say, is located, whether you're an institution or a business or a residential consumer, wherever you're located in Ontario, you will have access to a collection system in your municipality. And while I'm on that point, it's important to keep in mind that based on what you report as supply into Ontario, there's a formula to set your performance requirement. It's really, really important as a producer to understand that that's a minimum performance requirement. And the reason that it's a minimum performance requirement is that the collection system that has to be established has to be available all year long, and everything that gets collected has to be processed. That performance requirement is not a quota. You can't stop operating a collection system just because you've met your performance requirement. The collection system has to continue to be available to Ontario residents all year round, serviced all year round, and everything that gets collected has to be processed and will contribute to the performance requirement. So that's why we want to emphasize that when you enter into contracts with service providers, they need to be able to tell you how they're going to meet the collection system requirements, and you'll need to understand that the collection system is going to collect what it's going to collect, and everything that's collected has to be processed, and therefore you're not necessarily going to have a contract that stops at the number that's been calculated as your performance requirement. If you do have a contract like that, there's still your obligation to participate in the collection system. So there will be a gap in your commercial arrangements with respect to the continuing collection, and that will become a compliance issue for you as a producer. So the collection system sets up the requirements. There are rules for collection systems in the regulation. There's a distinction that's made from a small producer versus a large producer. So for the purposes of the collection system, a small producer is somebody who who has a management requirement of more than 3.5 tons and less than 700 tons. So that 3.5 ton is where the exemption. So if you're below 3.5 tons, you're exempt. If you're between 3.5 tons and 700 tons of ITAV performance management requirement, you will be a small producer for the purposes of the collection system requirements. And then a large producer is anybody who has a performance management requirement that's 700 tons or more of ITT. And this is all, of course, calculated on the basis of here's my supply data, here's the formula, and this is the result of the formula for the performance requirement. And then that's the number you can use to compare to the 3.5 to 700 or 700 and greater. So kicking in on January 1st of 2021, obligated producers are required to establish and operate a collection system. So for large producers, the collection system requirements are based on municipal populations, as you can see in this table, and the objective is that every single municipality will have at least one collection site available for end users to deliver used electronics to. I will note that the regulation specifically provides for the fact that collection sites can be shared by producers. And this is really sort of to acknowledge the practical reality that each individual producer who fits within the definition of large producer is not going to go out and set up a unique number of collection sites that meet the requirements of this table. That wouldn't make any sense, particularly since producers are generally going to contract with pros and other service providers to meet their collection requirements. So if I'm a pro, and I have 50 producer customers that I've agreed to meet their collection requirements, as a pro, I can set up a collection system that meets the requirements of the regulation and meets the requirements, therefore, of all 50 of my producer customers. Again, just to make this work even better, our approach to this from a compliance perspective has been to say, we don't even require a pro necessarily to have, on behalf of its producer clients, a collection system that meets this requirement. We're more interested in the totality of the collection system. So by April 30th of next year, producers and obviously more likely pros on behalf of producers are going to report in the collection system that they've established. What we will do then is we will say, looking at the totality of those collection systems that have been reported by whatever number of pros are reporting, and we currently have 4 pros who are registered with us. If the totality of the collection sites meet the requirements of the regulation in that every single end user in Ontario has access within their municipality or territorial district to at least one site or the number of sites that are dictated by the population, then we don't have a compliance issue. Individual pros with their individual collection systems, will continue to operate those collection sites in accordance with the rules under the regulation, and we'll be on the hook for ensuring that those sites are always serviced. So in the tire world, if a collector who's in a collection system that is part of the collection system of a particular pro calls us to say, I'm running out of space for used tires and nobody will return my calls and pick up my used tires, we know that there's a pro who's responsible for servicing that site, and then we're going to call that pro, and in every instance when that's happened, the problem has been solved right away. The pro arranges for a hauler to go out and get those used tires, and we're going to continue with that process for batteries and electronics. Another important feature of the collection system for large producers is that collection sites that are in municipalities or territorial districts that have a population of less than 1,000, or Crown sites that acquire used electronics, and First Nations that have sites that accumulate used electronics, have a right to contact a pro or large producer to get that ITT, those used electronics, picked up once they've accumulated more than 4 tons. So these folks don't actually have to be in a collection system because they have a right to be serviced, and because of that right, we, as we did in tires, will work with that group of organizations to understand and help them understand, that how to determine when they get to 4 tons and what their rights are, and then we'll coordinate with pros to service those sites as they require service. So that's the approach that we took in tires. It was reached on a cooperative basis with all of the pros based on their market share, and we would be looking to do something similar here as well. So this is a bit of detail for small producers. So if you're a small producer that whose performance management requirement is greater than 3.5 tons and less than 700 tons, then this is the requirement that has to be met. That's retail location based. So based on the number of retail locations that I might have in a municipality, I would have to have a number of sites that's based on that number of retail locations. Small producers, in our experience, have not really worried about this, because generally the small producers have signed up with a pro that's also dealing with large producers, and so the large producer collection system is more than sufficient to meet the requirements of small producers. So they're just piggybacking essentially on it and paying their share of the collection system along with the other producer clients of that pro. So, but it's there, and it may be important in specific situations for a producer to do it this way. But if they contract with a pro, they likely don't have to worry about whether they're a small producer or not. There are some specific requirements for each collection site that is in the collection system. So rule number 1, and it's a really important rule, nobody can be charged for dropping off ITT at a collection site. We've had a couple of instances in the other regulations where attempts have been made to collect money from somebody dropping off used tires, for example. It's a big no-no. The Act is very clear on that. Producer responsibility is covered by the product when it's being sold, and to the extent that the cost of managing electronics at the end of their useful life is being collected from consumers when they buy the product, whether it's part of the price or through an eco tax or whatever. To charge people when they're dropping off used electronics would be essentially to be charging people twice, and that's just not allowed. If obviously collection sites can be located in a retail location. If they're not in a retail location, they have to accept all forms of ITT and AV. If it is part of the retail location, at a minimum, they have to accept ITT and AV that's similar size and nature that's being supplied by a producer at that retail location. Has to be accessible to the public, has to be operated during normal business hours, and must accept at least a minimum of at minimum up to 50 kilograms. There's no restriction on them accepting more, but to the extent that a collection site wants to manage the amount of used electronics that it's receiving, they have to accept up to at least 50 kilograms per day from any person. And there's some record-keeping requirements if you're collecting more than 50 kilograms from somebody on a single day. The regulation also sets out the ability to reduce the number of collection sites that you might otherwise have to establish as a producer. So it provides for the ability to replace or reduce the number of collection sites through a curbside collection program, through a mail-back program, and through collection events, and the rules are set out in summary here on this slide, and obviously detailed in the regulation. The one thing that you can't do is reduce the number of collection sites down to zero. There has to be a minimum of one site or event in every municipality that has more than 1,000 people. So that brings us then to the management requirement itself. So in addition to having to establish a collection system and to operate that collection system all year and to process everything that's accumulated in that collection system, each producer has to meet a minimum performance requirement based on what they have supplied into the marketplace. So this really means that you're going to meet your resource recovery requirement by contracting with people who will provide for the refurbishment and reuse of electronic equipment or processing that equipment in order to recover resources from it. So recovering resources through processing basically is confined to materials that are actually used or destined to be actually used by a person to make new products or packaging. In the context of batteries in particular, there are some batteries that have chemicals in them that are recoverable and useful as micronutrients as fertilizers, basically. So to the extent that material is recovered from batteries, and the weight can count towards performance requirements. There's a recognition that that glass is a significant part of electronics, and recognizes that glass that's recovered during processing can be used in some circumstances as aggregate, but there is a limit on how much it can count towards resource recovery, and that limit is 15%. And there is material that potentially could be used as aggregate for batteries. This is specifically in the context of used batteries being sent to a smelter for the purposes of recovering the metal, and to the extent that there's slag left over as part of processing those batteries, that specific slag from smelting the batteries can be used as aggregate up to a 15% maximum. Of course, it probably goes without saying, but you can only count the weight of recovered resources once, and that's it. Can't be, and certainly to the extent that it exceeds the allowed limits for aggregate, it doesn't count. And to the extent that the material is land disposed or incinerated or used as fuel or a fuel supplement, it doesn't count. And if you stockpile it or use it as daily landfill cover, etc., or otherwise deposit on land, it doesn't count. So, except for the fertilizer piece for batteries, because obviously you're depositing that on land, but that's the one exception. And it can the amount of recovered resources can be counted 2 times its actual weight if that weight is the result of refurbishing by a refurbisher who's located inside Ontario. So a bit of an incentive to use an Ontario business and achieve refurbishment at the same time. Processors who deliver on processing have to meet a minimum recycling efficiency rate, and ultimately for batteries and for ITT, you can only use processors that are able to meet these recycling efficiency rates. There are some timing considerations of when this kicks in and so on, and that's all set out in detail in the registry procedure that's posted on our website and is referenced in the regulation, therefore part of the regulation. So the first time that a verified recycling efficiency rate has to be reported is for the calendar year 2021 and has to be reported by April 30th, 2022. The verification procedure for that is also set out in the registry procedure. This is important because based on the timelines and the rules that are in the registry procedure, once you get past a certain point in time, it will not be permissible to utilize a processor who's not meeting that requirement if you want to count their materials towards your performance. There are some promotion education requirements. Again, recognizing that individual producers have an individual performance management requirement and an obligation to operate a collection system which is going to drive their ability to achieve that performance requirement. It's obviously in the interest of producers or their pros on behalf of those producers to ensure that people understand that there are collection sites and events and so on available, or curbside collection programs and mailback programs. It's obviously in the interest of producers to ensure that consumers understand that so that they can actually drive the collection of those used electronics in order to meet the performance requirements. So the regulation sets out a minimum requirement for at least the first year, but the fact that there's no specified requirement in future years doesn't mean that you won't need to consider doing it, because your pros or your pros operating on your behalf, under their contracts, you're monitoring their performance, and if it looks like they're not going to be able to meet their contractual obligations with you, then you're going to you'll have to make sure that in your contracts you have some entitlement to promotion and education to be carried out in order to make sure that the collection system, in fact, can generate what it needs to generate to meet your individual performance requirements. So very, very important to consider all of these factors as part of the commercial relationship that you're going to enter into with any pro or other service provider. Ultimately, the failure to meet that performance obligation, is a compliance problem for the individual producer. And if it turns out that the collection system was being operated, but nobody was telling anybody about it, that's not going to be much of a defense with respect to being out of compliance. While I'm talking about compliance, I just want to spend a minute talking about the fact that the standard for the first couple of performance periods is a standard based on best efforts, and then after that, it's just the standard you have to meet. Best efforts is still a standard, still has to be met, is still enforceable. We are aware that some individuals may be under the impression that there's no enforcement under the best efforts, but that's simply not true. If you sat around and did nothing, clearly you would be out of compliance with respect to the requirement to use best efforts. So we've provided some information on what best efforts means from a compliance point of view, but it basically boils down to, did you take all the reasonable steps that you should have taken to be in compliance? And so, did you make sure that your collection system was up and running? Did you make sure that it was open to the public? Did you make sure they knew about it? Did you, take the steps that you needed to take when you saw that you were starting to fall short on your performance requirement, et cetera, et cetera? So it's really, really important, again, to make sure that when you're looking at commercial contracts with a pro, that you keep in mind this best effort standard that needs to be met, at least for the first couple of years, and then after that, of course, once we're past that transition period, what it means to meet the compliance obligations. Because at the end of the day, as producers, you're the ones that are on the hook, not your service provider. I mean, you may have contractual rights to enforce against your service providers, but from a compliance point of view, you're still on the hook for non-compliance, regardless of whether it's on a best efforts basis or otherwise. So on that, I'm going to stop again and take questions.
Great. Yeah, we do, again, have a number of questions. We'll only get to a couple here and then to finish off the presentation. And if there's any time left at the end, we'll answer. But if not, as mentioned several times, we will follow up with you directly if your question wasn't answered during today's session. The first question here, Pat, do pros have the ability to charge a collection site a fee for pickup, particularly in the situation of a population of less than 1,000?
So where a site has a right to require a pickup, they're obviously not going to volunteer to pay you. So I think that part of the question is easy. But generally, with respect to servicing sites, this is a commercial marketplace based on producer responsibility. So it's a producer's obligation to establish and operate a collection system and to set up a management system to recover resources, and that's all at the producer's cost. If you have the ability to enter into arrangements with people who are prepared to pay you, good on you, but that's a commercial arrangement between you and the person that is collecting electronics for you. Typically, collection sites have tended not to pay for the service because there's value in these products and there's value to processors in getting those products, and we all know about how schools can raise some money, and the Girl Guides and the Boy Scouts can raise some money by having an electronics drive, a used electronics drive, and so on. So, as I say, this is really down to the commercial marketplace. Producers are obligated to establish and operate and manage used electronics, and it's at their cost as a basic proposition. How that gets delivered in the commercial marketplace is really down to the players in that commercial marketplace.
Thanks, Pat. If the manufacturer arranges for direct collection of covered electronics from customers, do they still have to establish a collection site?
If the collection system is completely closed loop, they're collecting everything that they supply. I mean, that's a specific question that we would certainly be happy to take a look at. The ability to fully manage your own obligation and with a complete take-back system is available, and I think in that circumstances where an individual producer is recovering all of what they supplied, it would not really make a lot of sense to say to that producer, in addition, you have to do a whole bunch of other things, because you're collecting everything that you supplied, and that's your collection system, and you're going to deal with what you take back through refurbishment and processing, and you're easily going to meet and exceed your performance requirements at that point. We would take all of that into account when it comes to the specifics of a particular case. And so I won't say anything more in terms of those generalities. I think this is really a specific conversation between a particular producer and ourselves with their situation.
Thanks, Pat. That's it for questions for now. We can move on to the next section.
Okay. So talk about the registration process. So as a starting point, of course, as you all know, the OAS program winds up at the end of December. The regulation only came out last month, a few weeks ago. The regulation talks about, and the Act talks about an electronic registry, but clearly I think everybody can understand that between a couple of weeks ago and a registration deadline of November 30th, which is the end of next month, it's physically impossible to build an electronic registry for electronics. So what we've done is we have created a spreadsheet that captures the same information that's required under the regulation for purposes of registering and reporting supply data and calculating your performance management requirement. We have a list of potential producers that we have built from a number of sources, and so our compliance team is reaching out to have one-on-one conversations with everybody on that list. And of course, we will have that spreadsheet shortly available on our website so that producers can come in and into our website and download it. And at the end of the day, when the producer completes the registration information and the supply data information and understands what their performance requirement is and submits that back to us, what we'll do is we have the ability to open up temporary accounts in our Salesforce system at the back end while the electronic registry portal is being built for the front end, so that when that's completed, which we expect to be done and up and running by the end of June of next year. The RFP for the project just got issued this week. You will get a message from the authority with a link that will take you into the portal so that you can set your password and authorize the individual employees that you want as users on your account. And then you'll see that your supply data, everything that you reported in the spreadsheet, is already in your account. And then you'll be able to carry on with your annual reporting after that. So that's the approach that we have had no choice in taking. And what it means is that once you send your spreadsheet back to us, and the deadline is November 30th, and we understand that there may be some difficulties encountered by individuals, so we'll deal with those on a case-by-case basis in terms of time extensions. Once we've reviewed each of those spreadsheets, we will issue an invoice, and you'll have a 30-day period to pay the invoice. And again, if there's individual producers that have financial issues and need some time, we'll accommodate that on a case-by-case basis as well. And of course, once the registry is up and running, then we're back to the kind of normal operating procedure, which is on an annual basis, you're going to come in, report your next round of supply data, and before, as part of submitting that data, you will have to make your payment of your registry fee at that time. And then once the payment's been made, your report is submitted, and then you're done for another year. So the haulers, the processors, and refurbishers, we have a form already for those. A number of people have already registered. We already have 4 pros who are registered as well. And as a general principle, if you're not sure whether you're a hauler or processor or exempt or not, or a refurbisher or even a producer, our compliance team is willing and able to help you out with any questions you might have. So I think I've covered essentially the basics of the registration process and the spreadsheet-based form that we're using. If you were a steward in the OAS program, it's quite likely that you're probably a producer under the regulation and need to register. There may be some questions about whether that's true or not in every instance, and we'll certainly be happy to help you out with any questions you have around that as well. As part of the registration and reporting process, you have the opportunity to reduce your management requirements based on what you report in relation to three things. If you use recycled content in the form of glass or plastic in your product, you have the ability to use the weight. You can reduce the supply weights that you're reporting for that year by the weight of the recycled content that was in that supplied weight in that year. And then, of course, it goes into the formula to generate your management requirement, and that's how it ends up reducing your requirement. Another opportunity to reduce your management requirement is where you're a producer that offers a warranty at no additional charge to support the ongoing functionality of the equipment for at least 1 year beyond the first year after the purchase date of that equipment. And you can reduce your supply weight for that equipment that's subject to that warranty by 5% in every year that the warranty is actually in place for each year that the warranty is provided for beyond the first year purchase. So a bit of a complicated provision, but as I say, if you have questions around how it works and how it kicks in and what it means, particularly in the first round of reporting, again, our compliance staff are happy to help you out with that. And finally, the third way that you can reduce your management requirement is that where repair is available for supplied products. So through information that's available to consumers to actually repair the equipment and extend its life, and supplying tools and parts on a straight cost recovery period basis, you can reduce the weight of the supplied products for which that repair is available by up to 10%, by 10% in each year. And it's important to note that to the extent that you take advantage of one or more of these opportunities, the maximum cumulative reduction that you can claim against your performance requirement is 50% of your performance requirement. And there are verification requirements, and those verification requirements are set out in the registry procedure that's referenced in the regulation and posted on our website. So then I guess it comes down to the basic reporting question: how do I figure out what my supply data is? There's a number of options under the regulation. Obviously, the starting point is to figure out how many units you supplied into the Ontario marketplace to end users in Ontario. The actual number of units is a good starting point. You also have the opportunity as an alternative to use the formula that's specified in the registry procedure, where you know what your national sales are, and then based on the percentage of the Ontario population of Canada, that percentage can be applied to your national sales, and that becomes your supply units for the Ontario marketplace. And then, of course, you have to convert that into weight. And if you obviously know what the weight of your units are, then you do the math and report your actual weight. Or you can use the weight conversion calculator that's provided for in the registry procedure. And you also have the ability to look at the total weight of your product with its packaging and apply a packaging factor, based on a legitimate methodology that is ensuring that the weight that you end up reporting is in fact an accurate weight as opposed to a wildly inaccurate weight. And you always have the ability to bring forward a methodology that if it meets the objectives of this regulation, then we're happy to review those methodologies and sign off of them on the basis that they meet the objectives of the regulation. So there's some flexibility there. The performance periods, the first performance period is calendar year 2021. You have to use your best efforts to achieve a 55% resource recovery rate based on your 2018 supply data. And in 2022, you have to make best efforts to recover 55% based on the average of your supply data for 2018 and 2019, and so on. And you can see that the management requirement increases from 55% up to 70%, and then for every year after 2025, you have to meet that 70% requirement based on a rolling average of 3 years of historical supply data. So in 2025, your supply data, you will already have reported your 2020 data previously, your 2021 data previously, and then you would be reporting your 2022 data, and based on the average of those 3 years of data, your 2025 performance requirement would be a minimum of 70%. This is a very busy graphic, so I'm not going to spend very much time on it. It will be available as part of the presentation when it's posted, but it shows the relationship between each year, where the reporting requirements are, and the different kinds of requirements that are that have to be met based on the timeline. So I'm happy to take questions.
Sure. One question here. Are registration fees paid one time upon registering, or is this an annual fee?
Yeah, so under the statute, the authority operates on a cost recovery basis. So every year, the authority has to determine what its costs are for the following year, and then to determine what the fees are that need to be collected in order to recover those costs. So we just completed the fee setting process for 2020 registry fees. And the way it works is we look at each program and we assign the cost that program is responsible for to recover as fees for that program. So we have a fee for tire producers that's based on the cost of developing the tire registry. And we have a fee for a blended fee for electronics and batteries to recover the cost of operating the battery program. That fee will recover the cost of the development of the registry, and it also recovers the cost of the compliance program. And so, based on the number of programs we have, we allocate a portion of the staffing and overhead costs and so on to each program for recovery in fees. So all of which any of you who participated in the recent fee setting consultation process would have seen in much more detail than we have time to get into today. So it's an annual requirement. It's not a registration fee. It's a registry fee recovering the costs of operating our program. And we will have a 2021 fee setting process that will start at some point in 2021 for the purposes of setting fees for a number of programs that will include the new programs coming out in the next regulation, MHSW, that's currently underway at the ministry.
Thanks, Pat. I think we'll maybe we just move to the next our next and final section, just as we are kind of getting close on time, and then try to respond to a couple more questions at the end.
Thanks. Okay, so there's a number of players obviously interacting with one another under this regulation. So I just want to spend a few minutes talking about those relationships to help you understand how it all fits together. So in this graphic, you can see that all the players are here. So we've got the authority, we've got producers, we have pros, and then we have the other service providers. And the yellow arrows really are there to designate the regulatory relationship that exists between RPRA and those three groups. So all three groups have to register with the authority, and they have to report to the authority. So that's the regulatory relationship. The black arrows represent the competitive marketplace that happens. So, and we are obviously not involved in that. So producers, pros and other service providers are going to contract with one another with the objective of meeting the producer requirements, which then, based on the yellow arrow, get reported up to RPRA. So pros are going to report on their performance. They're going to potentially report individual producer performance on behalf of those producers, or the producers will report it, and the other service providers will also have some reporting requirements based on what they do. So that's basically how it generally works. So it is a fundamentally different program from the IFO-based program, and it is really, really important for individual producers to understand that there are fundamental differences, that they now are looking at a competitive marketplace, that they have a number of options available to them, and that the one option that isn't available is it's going to be exactly the same as it used to be. That is simply not an option under the new program, because it isn't exactly the same as it used to be. Individual producers are now individually responsible for performance, and they never were before. So our best advice is take a look at what's available in the marketplace, and then pick the option that works best for you as a producer, and fundamentally make sure that when you're entering into those relationships, that there's a complete coverage of how the collection system is going to be managed, how it's going to be maintained, so that it's in compliance with the requirements of the regulation year round and open, and actually and how people in Ontario, end users in Ontario with used electronics, will even know that it exists. How is that going to happen? How are you going to make sure it happens? What happens with respect to how performance is being monitored through your normal contract management processes, and what steps should you be taking when performance is not in line with the contractual expectations, knowing that your individual producer obligation leaves you at risk from a compliance point of view. And obviously, pros are going to enter into contractual relationships with other service providers. Our expectation is, as we've seen in other programs, is that when it comes to verifying performance through a third-party verification process, the vast majority of producers are not going to engage their own auditors to do that. They're going to rely on their pro to engage the third-party verifier, to carry that out on behalf of all of the pros producer customers. And it's really, really important for pros who are entering into contractual relationships with other service providers that built into those agreements are audit rights, because obviously if an auditor can't access a service provider for the purposes of verifying performance, then the auditor can't give an opinion on the performance, and then the audit requirement can't be met on behalf of producers, and so that'll become a compliance problem for the producers who can't demonstrate that they've met the performance requirements under the regulation. So all of these things are just normal commercial due diligence, but it's driven by making sure that there's a true understanding of the requirements of this regulation for achieving performance on an individual producer basis. The relationship between the key players and ourselves, I want to emphasize that I think I saw a question in passing, what is the relationship between EPRA and RPRA? We are the regulator, and EPRA is an example of a service provider, one of 4 registered pros, and all registered pros essentially have to register and report to RPRA. They are regulated parties. We don't administer contracts, review contracts, oversee contracts. This is a outcomes-based regulation. Contractual responsibility is with the producers and their pros, and the ability of those commercial contracts to deliver performance, is driven by duly diligent contracting practices and contract monitoring. So we don't pay incentives. We don't pay for the processing or transportation of used electronics. Again, we're just the regulator, and there's a competitive market that takes care of all of the actual performance requirements. I referenced this early on. A pro is able to submit performance information into the registry on a producer's behalf, and so the pro is in a position to report the collection system for their producers, the refurbishers and processors for the producer's management system, and of course to report all of the weight of what was recycled or refurbished in order to meet producers' performance requirements. So we've got well worked out functionality that allows all of that to happen, and it's worked very well so far, and it will continue to work well under this regulation as well. So obviously, fundamental question for each producer is, well, do I need a pro or other service providers? I think generally, as a general statement, producers have their individual collection requirements. They always have the option of trying to meet them themselves, and there may be circumstances where that's doable, and that's great. But typically, a producer is not generally in the business of collecting and managing used electronics, and will typically want to rely on service providers to do that. So that can be done through hiring a pro under contract or contracting directly with haulers and refurbishers and processors to organize it for yourself through individual contracts. So you're likely going to need the services of a service provider, a pro or otherwise, but ultimately, regardless of those contracts, I think it's really important to emphasize you still remain legally responsible for those. You can't contract out of those obligations. You can simply contract with somebody to help you meet those obligations, but they always remain with you. Generally, again, I just want to emphasize this based on what we've seen happen in the transition years for tires. Just make sure that where it's required, that where audit access is required, that those commercial contracts have that kind of audit access built into the contracts. Becomes really, really important because, of course, a processor doesn't necessarily reside in Ontario, and if you are retaining processors in other jurisdictions, they still have to register and report to us, and their performance still has to be verifiable. So really, really important. There's no deadlines, obviously, for retaining a service provider. The only deadline is that by the end of the performance period, have you met your performance obligation? So, but obviously, you need to hit the ground running, and obviously, it'll be a bit of a challenge to hit the ground running given the late delivery of the regulation versus the January 1st start of the new program with the wind-up of the OAS program at the end of this year. We do have 4 pros registered. This is their contact, their names and contact information. We will send this out to our list, and we'll post this on our website as well. And of course, it's in the presentation, which is also going to be presented on the website when we finish this webinar. So I'll stop for questions again.
Great. Thanks, Pat. Question here. How does this new regulation impact the visible fee process that is currently in place? So the regulation is silent on visible fees. Basically, individual producers are going to have to make their own business decisions about meeting their financial obligation associated with their performance obligations under this regulation. Producers can treat this cost as just like every other cost that goes into their product, logistics, overhead, materials, manufacturing, transportation, it doesn't matter. This is one more of those costs, and then there's a cost that their product is sold to recover all of the costs and make a margin. So the alternative, of course, is to isolate this cost as a separate fee. And I'll say 2 things on that.
the basic rules that are in play is the fee has to be covering an actual cost, and otherwise it's a misrepresentation to a consumer who's paying that fee, and it has to be described in a way that isn't a misrepresentation as well. So we have seen an unfortunate tendency from a compliance perspective at the retail front line, when people ask what the visible fee is for, people are saying that it's a mandatory government charge, which of course it's not. It's not even mandatory, and it's definitely not a government charge, or it's a tax, which it definitely isn't, or it's an amount that has no relationship to what it says it's for, which of course is also not true in those circumstances. So this is an important area of risk, particularly for retailers. It's an additional administrative burden on a retailer who's charged with trying to collect these fees. And ultimately, that's where the risk is in terms of people experiencing misleading or misrepresentations and so on. The consumer protection people can take a dim view of that behavior, and so can the Competition Bureau at a federal level, because it raises competitive problems and issues as well. So certainly, I think people can understand that there's been prior experience in Ontario with that risk with eco fees and the problems that they create. So, but as I say, this is really down to individual producers to determine how they want to proceed and what risk they're prepared to take on and how to manage that risk. So I won't say much more about it. Clearly, in other sectors, we've seen similar problems. The airline industry was notorious for tacking on all sorts of crazy fees after people saw a nice price, and it turned out that nice price was actually several $100s higher because there was all these fees that were mandatory, not really. And ultimately, government of the day had to say all-in pricing. We've seen the same thing for new vehicle pricing. There's an all-in pricing requirement for new vehicles when those prices are being advertised and so on. So I just highlight it because there is a risk, but it's really down to individual producers what they're going to do about this and how they want to administer a visible fee if they choose to go down that road.
Thanks, Pat. So we are at time. I will just quickly say, again, thank you for all of your questions. Obviously, we were not able to get to all of them. We still can spend a couple minutes. Obviously, we're going over time, but we can respond to a couple more. But in the meantime, I just put up a slide that if you have more questions, please send them to our registry team at the information on the slide. And of course, visit our website for more information. We will be following up with people afterwards whose questions were not responded during the session. So please stay tuned for that. So Pat, I don't know if you want to maybe answer one or two more.
Sure. The other thing I would add is that we're going to go through all the questions that we didn't get to because of the time constraint. And if we see some important themes in those questions, I think we're considering having some additional sessions to focus on those themes so that we can address them on a collective basis like we did today. And where there's very specific questions to individual situations, we will follow up on those individual questions. So I'd like to thank everybody for their attention on this, and I think there's been some very good questions, and I really hope that you take advantage of our compliance team to pursue any additional questions you have. And as I say, we're going to do some follow up on the questions that we didn't have time, unfortunately, to reach today. So thank you very much, and I look forward to working with everybody as we go through the transition into this new program.